That's it. We are online. If you're on the replay crew, skip ahead. We're going to do at least 15 minutes of tech checks and getting everything in sorts. So if you're feeling out of sorts, this is the place to be. If you're in sorts, come back in 15 minutes. If you're live, you've got no choice. Stick around. Just to get my audio right, we'll read a little news article that came across the D&D community page a few days ago. Judge Jackson decision leak. In a judgment expected to be delivered by noon, April 1st, 2026, Judge Jackson intends to rule largely in Sarah Boone's favor. To wit, petitioner will continue to pay alimony in full at $1,000 per month. He will open and maintain a secondary bank account to deposit funds and transfer the maximum amount allowable per week to respondent. Petitioner will deposit back alimony from the date of respondent's incarceration, February 2020, to present. Petitioner will bring son for weekly visits. Oh, I got to start that timer. I'm not even on the right page. My God. Oh, yeah. No, this is all... I'm totally out of sorts. This is why we have a warm-up. Start it. There we go. All right, the timer's begun. Petitioner further instructed to bring son for weekly visits, including weekends with football games scheduled. Petitioner will purchase a 2011 Kia Sorrento to park outside the prison for respondent to look at while exercising in the yard. Petitioner will be responsible for maintenance and upkeep, so vehicle is available to respondent immediately upon winning her criminal appeal and leaving Lowell. Petitioner is instructed to care about respondent's feelings. Petitioner's son is instructed to man up. Petitioner instructed to pay respondent's attorney's fees at a rate in keeping with the highest paid Florida defense attorneys, reflecting respondent's excellence in preparing her case. Members of the public who disagree with this decision are advised to check their calendar and proceed accordingly. This was posted on April 1st. All right, I see a few members of the chat are here. It says YouTube is not currently receiving data for this stream. If you think this is incorrect, and then the window pops away. I have a feeling you are getting data if you're here in the stream. So I'm not going to worry too much about that. I will access my own stream just to make sure it is available on my phone. I'll turn it down first. Using a headset today, this may improve the audio, maybe causes more problems. We'll see what happens. D&D True Crime, view channel, view lives. D&D True Crime Live. Oh, I forgot to really name it. I just called it live broadcast. Okay, I'll fix that. ADG Farside is here. Fantastic. Yes. Oh, subscribe. How do I... Okay, what's going on? ADG is trying to subscribe through the computer instead of the phone like suggested. Please know that if I lose my bloody keyboard. I think you can subscribe through either, but if you're signing up for a membership, do it through your computer. Because if you sign up for a paid membership, then Apple charges an extra 50 cents if you're doing it through an iPhone. But I can be on my Mac and do it, and then it's at the cheap price. So, yeah, don't pay full price. Get to a computer and pay less. So I see Addy is me is here. ADG Farside is in the chat. A to B is here. We have, it's like everyone's showing up in alphabetical order. All the ADs are in the house. Where are the AEs? I need my Aether friends. Okay, we've got 12 minutes. I have time to enjoy a coffee, maybe light up a medical cigarette here. Give a little tour of my medical snacks for the morning. I've got a banana and... Oh, Jesus. Trying to show it off to the camera. I have a chocolate chip banana muffin and a caramel toffee chocolate bar from Walmart as my medical snacks. That should keep my blood sugar up to an acceptable amount. Got a bit of a fun show. We're just going to rewatch some classic Sarah content. So if you're a fan of the Sarah Boone content, today's show is for you. A to B has the day off. Woo! Party! All right, getting started early with the medical drinks for A to B. Pineweaver, welcome. Pine Weaver's taking us all on a hike. So if you don't feel like exercising, just hang out in the chat. Pine Weaver's taking us for a walk by proxy. Pine Weaver, how did you show up with all the A's? All the A names have showed up in chat first thing in the morning. All my straight A students with an A to start their name. And Pine Weaver showed up with the rest of y'all. Back in the alphabet, but keener, here to stay. All right, let's light up. There's no point in doing a warm-up if I'm just going to talk the whole way through it. I'm supposed to just mellow. Medical Oreos are in Addie's medical snacks tray. Kind of exciting today. If you guys have nothing to do and you're a little bit concerned that this show feels like it might be a shorter one than normal, you're right on that. I'm going to go with a hard 2 hours. We're going to try and end it at exactly 9 a.m. my time. The reason for that is that Paul and the Sofa Squad are doing a rewatch of the Afro Man trial. And it is hilarious. He's already done a couple hours of coverage. He's only doing about 2 hours a day, but I think even then he's going to get through it in 5 or 6 days. But, oh my God, his reaction to Lickum Low Lover being played was just is so good. So I think he is queued up to watch Officer Poundcake's testimony as well as Randy Walters. So when we go offline, I'd love if everyone who has the time is going to leave my chat, jump into his, leave a little sofa and a blue heart in the comments. Let Paul know that Dan D sent you. He keeps calling me D&D, so let him know that Dan D sent you. D&D is cool, but it's been a few years since I played. D&D true crime would be quite a thing. Then the wizard killed him with a fiery spell. The warrior came out. I want to be pro se. All right, so we're hiking with Pine Weaver. I started my show with a little bit of my April Fool's gag for anyone who had a chance to be peeking through the community tab. A little fun at Judge Jackson's expense, taking her time to deliver a verdict. So delivered the one that Sarah's looking for. We've got David D saying morning D&D. He's another D&D in the chat. Welcome D&D Dave. David. Going to light my already lit joint. This is why you got to warm up. You're not feeling at full speed until you've had your warm up, right? Have a little extendable back scratcher here. This is, oh, that's exactly the spot. Oh, these are great. Everyone should have one of these. Pine Weaver has all the days off, retired and loving it. Also, I'm free because I didn't stuff and snuff anyone in a suitcase. Sarah is where she belongs. I don't have my bell. I'll be right back. I need my dinger. I'll be right back. You guys just hang out and enjoy each other's company. I don't even have a dog to show you. Well, chill. We got the timer. We'll hang out. Be right back. I need my bell. right. Oh my God. Wrong bag. Be right back. How are we doing on time? 6? Takes me a minute and a half to get down to where the stuff is. Okay, I'll be right back. Oh, okay. Pine Weaver is correct. Hello. Lola is here. Hello, Lola girl. You want to show off your haircut? Lola just got back from the groomer yesterday. Oh, don't you look soft and... You're not rugged at all, are you? Used to be a little rag doll. You know what a rag doll is? Sweetheart. Okay, onto the couch. Onto the bed. All right. Whew. A lot of effort. Ah, okay, so it's Brody, his Pine Weaver, and that explains why she's in here after the A's. Curious Koi, okay, so we've got our A's, our B's, and C's. All the ABCs are here, fantastic. ADG Farside has a cat named Bucket. She's at home. I have a cat named Cat, short for Cadillac, but still it's Cat. Come here, Cat. Cadillac, you ought to know by now. It's time to eat your dinner. So get in there and eat out of your bowl now. And it seems like a waste of time. Honey, if that's eating food, then I'm feeding cat. Ba-da-da-da-da. All right, got some Lola fans in the chat. My God, what's happened to the timer? I'm not ready to go yet. Fuck. Okay. Those runs downstairs really took it out of me. Obviously, when you're out of breath, the best thing you can do is smoke. Pets are the most understanding family members. They have an empathy that I think there's something... Language gets in the way of true empathy for each other, I think. I think being able to describe our emotions is, what sets us apart. But at the same token, because we rely so much on words, we kind of undeveloped that sense of, hey, something's wrong. Maybe you want somebody just to sit beside you. Dogs, cats, they kind of get it. They'll just lean against you. They'll give you the energy you need. Yeah, these are medical cigs. It's been, so just for clarification, I am smoking recently legalized smoking product. I think Canada, funny enough, we legalized it on April Fool's Day. Can't remember if it was in 2018. Whenever we did, it was April Fool's Day, which is kind of funny. But yeah, I quit smoking regular cigarettes. God, I think it think it's been about 25 years now. I still smoke in Vegas, but it's been about 10 years since I've been to Vegas. Mostly because I drink too much. So if you smoke, you can stop drinking because raising your hand with a cigarette. A to B has a little pup named Izzy. Got the eyes in the house. A to B, or Addie is me, was thinking about me last night because she hates hockey, except for, what kind of hockey? Except for sled hockey. Oh, sledge hockey's awesome. Those guys are amazing. Mostly guys that have lost use of their legs, but the way they go pounding in, like, they lead with their legs in these little sledge. It's just, if you think wheelchair basketball seems, rough and tough, sledge hockey is amazing. Like, it should be a much more watched spectator sport than it is. Oh, but Addie was at a regular kind of hockey game, and it was so boring. I have a playoff game to go to for our local team tonight, so I have an early show set up for the ramble. Oh, shit. Why do birds suddenly appear every time you are near? Paul Klink in NYC, welcome to the chat. ADG Farside has a flat-faced purdy kitty named Mooshie. The M's are in the house. All right, this looks like we're starting the show. I'm not fully ready for it, but, fuck it. Here we are. It is early. It is before 7 a.m. on the West Coast. It's just approaching 10 a.m. in Ocala, Florida, which means they're probably getting lunch ready because everything gets done quick there. I have a bit of a fast-paced show for you today. My plan is to be finished the show in time for everyone to run over to reporting live from my sofa. Paul and the Sofa Squad is covering the Afroman trial. And if you saw me covering the Afroman trial, I did cover the Afroman trial. I also cooked a little lemon pound cake. I'm going to skip through my video a bit here. Rinds. Oh shit. I got chocolate on my screen. Oh, I've only got this in the little window. Okay, that's fine too, though. Don't fuck around. We don't want that happening. That's not enough bowl for all that sugar. Get to it. Okay, I'm going to show you guys the cake pop, but then you guys can tune into the full video. Oh. Hey, Michelle Fournier. Flip it. Reverse it. Fuck yeah. Fuck yeah. That was so good. All right. We'll show it with a little glaze. Oh, yeah. So anyway, that's all available on my page. If you guys want to make a cake, I would love to see your lemon pound cakes on my community tab. I set up the video to be snarky, has commentary, but it's also a fully functional recipe. So all the steps are there. I fast forward past the parts. I respect your time. I'm not going to show you 12 minutes of that. I'll show you 4 minutes of that. But yeah, it's a fully functional recipe. You may have to pause it at a couple of spots where I fast forwarded it, but there's no, trick maneuvers where I pull the ready-made pie out and swap it for the other one like they do on TV. If you're interested in making a lemon pound cake, everything you need to know is in the recipe, and I'd love to see what you guys are able to do. Any comments on the headset? This is a new headset. It's a Walmart brand. It's a cheapie, but I thought maybe a new cheap one would be better than my old expensive one. And I did a test. I recorded, 2 minutes of audio. I think I sound better. But if there's any complaints, by all means, complain. Dan D, do you know Willie O'Ree? We used to go to San Diego Gulls Monty hockey games when I was a kid. A to B, do you think I'm from San Diego? I am on the West Coast, but no, and I'm not that, I'm a hockey fan, but I don't know all the minor league teams. San Diego Gulls. But no, don't know Willie O'Ree. I'm sorry. Another one to say is here in the morning. Fantastic. Let's have a look at what I have planned for today. I think what I am planning, I want to get rid of that. I want to add that. We'll do that. Little of Sarah Boone's greatest hits. So I've done a few off-topic shows. First black player in the NHL, but originally from Canada. Okay. Well, now I'm going to have to look into that. That's a cool bit of info. So A to B shares with us that Willie O'Ree, first black player in the NHL, originally from Canada, and was watched with the San Diego Gulls when A to B was a kid. That's super cool. For the first black player I remember as a kid was Grant Fuhr, who was the goalie for the Edmonton Oilers. And because he's goalie, you didn't even know that he was black, which probably helped him as being one of the only black kids playing in a very largely white sport. Racism's not as bad in Canada, but you can tell when you're different, when you're the only one that's, everyone's white and you're not. It's, you don't need there to be racism to feel different. In any case, that's a cool little story. Great way to start the morning. Thank you for that, A to B. I see somebody called Brat. It's not J Brat in the chat, is it? I haven't seen J Brat for a while. LZB is here, though. No, I think another one to say is just calling someone a brat. All right. Sarah Boone's greatest hits. We're going to start with the snacks motion. I have a little playlist set up of a few of her, kind of greatest hits, funny moments, stuff that we can just have a good laugh at her and enjoy our morning. So that's how we'll be getting it started. LZB can't stay, but she got a new part-time job as a bud tender. Good luck. That is awesome. I will, in LZB's name, I will puff on this. This is just for support. I don't really need this anymore, but you're going out to be a bud tender. I'll smoke a little bud in your name. To LZB. All right, so let's get this started. We don't have too much time to fuck around. I think I have a video scene. Yep, that's how it looks. That's how I started the show. This is accidentally got this set up. Okay, so we will start it with a little bit of play, and I will be able to relax, chat, and enjoy this with you. Oh, setting it up. This is James Owen's big judge, Sarah, who she's wasting away. She gets barely a jelly sandwich in the morning. She gets her bunk kicked at 2:30. Judge, I'm just trying to tell you what Sarah's making me ask for, even though I know it's bullshit. So can you just let me get through this? Okay, here we go.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one.
If Pineweaver didn't already tell me the name is Brody, I would have thought that he's Eminem, because Pineweaver says they grew up as the only white kid in a Detroit neighborhood. Racism goes all directions. Yeah, no, I wasn't insinuating in any case that it's only one way, but for the only black kid in hockey, it's definitely one direction for that. When I grew up, like, I didn't even play hockey. I did figure skating as a kid so that I'd know how to skate. Because my parents, well, hockey's expensive and it requires a huge time investment from parents. If you're a kid, the only ice time you get is like 3 or 4 in the morning. So it's a big deal if your kid's playing hockey in Canada. So I learned how to figure skate, and I'm still, when we get out to the rink, people are like, wow, you're a good skater. They don't know that I learned it from figure skating and not from hockey skating. But anyway, that's all besides the point. Michelle Fournier is a Blackhawks fan. Sweet. I have a signed Patrick Kane jersey from the Blackhawks. I used to work for EB Games, and our store sold the highest year-over-year increase in the NHL EA games. So I got myself a jersey.
She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy.
5 peppermints, 2 bags of chips, bag of candy. Sarah just staying there stone cold, like, this is totally normal. We're even going back. Fuck. I love this. This is probably my favorite of the non-trial footage of Sarah.
That escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not in the state attorney's office and any of the parties involved.
Okay. I will speak to the captain of the jail.
Claire,
if I can get a hold
welcome.
of her before
Ocean
5 o'clock
Sounds.
tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs.
I've just got word that cookies are provided to inmates. I love how the woman comes in, like, we're going to go back to that too, but she's got to be sitting here off camera listening to James asking for this, going, they get fucking cookies? What the fuck? Judge, shh. So look how she comes in. It's like, you need to see this.
We can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right, anything else?
This woman is on trial accused of committing a murder, and she's concerned about her snacks.
Yep.
Snacks.
To what, 9?
I love how the host there went and got all those snacks. Like, you know that some production assistant got sent to, go down to the commissary and get me Lay's chips, dill pickle chips, and I want them all for myself afterwards. I think this cuts back.
Years now, and this seems to be consistent with what she has done leading up to this point. I guarantee she had this conversation with her defense team. They probably told her, no, we're not going to ask the judge that, and she probably pushed back, and they thought, you know what? Just to cover ourselves, we're going to ask the judge, as crazy as it may be. And I guarantee you this, the defense attorney was embarrassed to ask for that request. When he turned around, he looked like the most embarrassed person in the world because he knew how silly it was.
And that said, that was just getting started. That was the humiliation ritual to get James Owens doing everything the rest of the trial, because there's so much that he had to ask for. So many crazy paths of evidence that he had to follow because of his client. So this just kind of whipped him into shape to accept everything that she had to offer, which, I don't know, good or for bad, good for entertainment.
He knew how ridiculous it was, but he still has to do what his client is asking him to do. And here we are with another crazy request from Ms. Boone.
Yes, Randolph, you're so right. You said what we are all thinking, that attorney would never want to ask those questions of a judge. Would never think of that, but because he's got a...
She expressed, it was a 2-week trial, she wanted to wear something different every day. They expressed to me that if I would just bring her clothes.
Let's just remember, too, the first day of clothes that James brought in was like a blue smock that looks almost exactly like her jail outfit. Thanks, James. Good purchase.
Every morning, whatever she wanted to wear, and then pick them up in the evening, the clothes she wore that day. That would work with them instead of going to the visitation center and that whole process. So I think...
Great point, Claire and Marie. It's like you might as well have gotten up and started singing Incense and Peppermints. Like, my client wants incense and peppermint, sugar and spice.
It's probably the way to go.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30 today to try to figure out what the issue was with the clothing.
That's the last time you see Owen smile this whole trial. That's I didn't realize that, but he usually has this face. But
And that saves the phone call that I had set up with Captain DiGiovanni at 12:30.
I don't think we see smiling James ever again. It's the last of smiling James Owens.
To try to figure out what the issue.
Look at that. He's positively mirthful. He has no idea how shitty his life's going to be. Sarah knows, but James has no idea. He's happy.
With the clothing.
Is always an issue with her, Randolph, as you know. Would you speak to how things typically go when you're getting a client ready for a trial, and if they're being held in jail prior to the start of the trial?
Apparently snacks is something that is normal for, that was Utah, that was Corey Richens, right? Afroman's trial, they were allowed to have snacks too. So yeah, it's not, but I guess Florida is like, snacks. This is Florida, bitch. You're not getting fucking snacks.
There are challenges. We acknowledge that. Would you kind of speak to what's normal in the process, Randolph?
Sure. So each jurisdiction is different, and it depends on how the sheriff's department or the department that controls the jail and does the transport deals with each inmate.
12?
Some departments would rather have the attorney bring the clothing or the family member bring the clothing to the jail, allow the defendant to get dressed at the jail, and then transport them that morning in the clothing.
Let's watch.
Here's the ruling.
Your Honor, could you please repeat the question?
Sure. The question was, without going to any specifics.
Is that Billy Lane in the background? He looks really good there. I always have seen him from the back as he's approaching the stand, but that's a pretty sharp suit. Black with the white tie popping. I like that look.
Conversations that you've had with you and your attorneys. Are you in agreement with the persons that have been identified in that list that may be called as witnesses in your case?
I'm not familiar with everyone that's on here, but I do agree with whoever it is that they have on here.
Okay.
Ooh, okay. Randolph, you know what,
ADJ Farside says, I picture Owens on a beach somewhere, sitting in a chair with a blanket over his lap, staring at the water, nonverbal. 100%. I could just picture the 1,000-yard. Like Putty from Seinfeld. You're just going to stare at the back of the airplane seat this whole flight? Yeah. Yeah, that's right.
Oh, what do I want to say? What's the expression? Dumb like a fox, right? She kind of played a little dumb there about, well, I don't know who's on the list, but I guess I agree. Do you think she's trying to set up some kind of post-conviction relief for herself or ineffective assistance with some of these comments she makes?
I certainly think she is. She is probably trying to lay the groundwork for either a appeal or some sort of complaint against.
Speaking of appeals, have we all heard about Letitia Stout? Give the chat a second to respond, but the appeal for Letitia Stout was big news yesterday. And I guess it holds out hope for Sarah. There's still, I guess, an avenue for appeal because I never suspected what worked for her. But I guess there was a juror that was 3 degrees of separation related to the prosecutor. So, not a direct relative, not an indirect, but what, indirect. Regardless, that's enough. She's getting her, Letitia Stout, who was convicted of killing Gannon, won her appeal. So that's pretty fucked up. In any case, so Sarah still, I guess there's, but I doubt it.
Attorney saying that they didn't provide me this information. I never got to look at it. And that could certainly be a basis for an appellate court to look at this case and say, well, you know what, we need to give her a new trial. She's being very sly. Again, this is the Sarah Boone show. She thinks she's smarter than everybody else. And so I certainly think she's being cryptic. I think she's maybe trying to be a little difficult, which, look, she's going to be difficult through this whole trial. There is no doubt about that. So, with the food request and the clothing request. And by the way, Julie, do you have any more Pop-Tarts? Could you send some to me, please?
Yes, Randolph, absolutely. You deserve all the Pop-Tarts. You're one of our favorite legal analysts. And gosh, I know, I wish I could, send some through the television to you right now.
But I'm taking them all home.
Yeah, we should get snacks, right? We don't snack, we do our jobs. That's what we do.
Did I miss the ruling?
My goodness. Randolph, do you think the judge, before we hit a break, do you think this judge is going to grant this request? Because at the end of the day, it's in his hands, as you know. What do you think?
No, this judge seems to be a no-nonsense kind of judge. He's going to call it right down the middle. Remember, judges are there to call balls and strikes, and they're going to take the law, they're going to take the current rules that have been set up by the courts.
I don't know if she took her shoes off, but another one to say asked about that, and I totally am reminded of Paul doing the voices, like, I'm not wearing any shoes. When he did voiceover for the trial, muted the audio of the trial and just did like bad lip reading. And one of them was Sarah whispering over with a smile, like, I'm not wearing any shoes. And no one's just had a stink face.
Say, look, I'm looking at what you present to me. I'm going to look at the facts. I'm going to look at the law and what the courts have said, and I'm going to make a call here. I'm going to make a balls and strike decision here, and we're going to make it reasonable. And so I think he's going to make reasonable calls, but I don't think he's going to put up with her shenanigans as this trial proceeds.
Right. And we know she doesn't have a medical issue of low blood sugar and doesn't have a need to have candy or juices there at the desk. And the jury's not getting it, right? The jury's not getting snacks to munch on. So why should she?
Hey, Julie, 2 hots and a cot. That's what we always say. That's what you get,
2 hots and a cot.
The sheriff's department is providing plenty of food. It sounds like she's getting a peanut butter and jelly sandwich, and it sounds like she's even getting cookies. I don't even get cookies during my lunch, so she's doing better than we are.
We got to talk to somebody about that. We got to get some cookies for Randolph Rice and some Pop-Tarts. You're the best, Randolph. Stand by kindly, if you would, please. We're going to hit our first break of the hour right now, friends.
Okay. I guess I don't have that. I'm going to look for it in the side window.
We are switching gears now to Florida, where defendant Sarah Boone is now going to be representing herself at trial. There was a last-minute hearing on Friday, and the judge in that case said 8 is enough, granting Boone's former attorney's motion to withdraw and ruling that the defendant has now, on her 8th lost attorney, forfeited her right to counsel because of her ongoing difficulties with all of those other counsel. At a status conference last month, we heard Boone express her frustrations and telling the court why she thinks that things could be going better, saying, quote, she was doing her best.
I found the snacks motion. We'll come to it after this one.
untruthful with me and full-blown prejudice against me, which I believe adds to her nasty attitude towards me. And I do not trust her.
This is good too.
I have prepared this for you. It's a letter and then a continuation of the letter from the video visit, so you are aware of. And everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them. I put this in here also so you are aware. I refuse to be mistreated by her as my attorney. I'm shocked that she has a proposed trial date, considering the fact that I have not seen anything. I keep asking her for just a download of my phone or my medical records or for anything that I've asked pretty much all of the other attorneys as well. All of my questions.
Yeah, the snacks was 100% Sarah. It's an example of something I've brought up a few times. I'm going to refresh my screen here and remember where we are. 136 in. She's always focused on the least important but most urgent thing. So an example of this, like when I did middle management work, they were like, when the phone rings, that has urgency. If you don't answer it, it's going to stop ringing. But it's not the most important thing. If you're doing something super important, as urgent as the phone seems, deal with what's important. And Sarah is the complete opposite. Phone call, whatever the latest thing that's ringing in her head. And if it's, a little hunger pain, I should have snacks. You know what? Instead of working on my case, I want you to waste a bunch of time drawing up a snacks motion. 5 peppermints, 2 sandwiches. It's such a bizarre way to go about life. Let me get back to 136 here. And I found the snacks motion, so we'll watch that after this video.
Well, all of my questions that I keep asking her are in a letter to you. I didn't know if you would be the one to help me answer them or to spur her to finally answer them to me and hopefully truthfully. I don't know. As I've said to you before in the past, you said that you are not able to intervene regarding my letters. I still want you to be aware of what it is that I am going through still. And it's a matter of ethics and professionalism with how she should be treating me. I shouldn't have to come up with a pretend judge in order for her to do so. And also some other things that I've been working on in the meantime that I would like everyone else to be made aware of. That I don't just sit and eat bonbons and watch.
Pretend judge. So this is why these made the list. I think that was first mention of pretend judge. Love pretend judge. I love that she invented pretend judge. Thank you, Patricia Cashman, for making Sarah invent pretend judge.
And professionalism with how she should be treating me, and I shouldn't have to come up with a pretend judge in order for her to do so. And also some other things that I've been working on in the meantime that I would like everyone else to be made aware of. That I don't just sit and eat bonbons and watch soap operas all day. I fully apply myself at all times. The court.
She doesn't eat bonbons and watch soap operas all day. She thinks that she was Al Bundy's wife, Peg Bundy.
I've spent probably 20 hours, a little bit more, a little bit less, with Miss Boone. She has lots of lists, lots of questions.
She has lots of lists, lots of questions. And at this time, Kranick was still super fair to Sarah. Like, he hadn't seen the interrogation video. He didn't know a lot beyond the letters. And, to his credit, had been pretty even-handed with her. But poor Patricia Cashman trying to explain what it's like to deal with her in a professional manner with, pretend judge and real judge in the courtroom.
In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
Hang on, please. No one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through her questions, going through her lists. When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out. She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy
Busted.
previously. She'd reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, and you try to explain that to a client. You know, I know the court's in a difficult position, but at this point, we're at that impasse of, if she walks out of every conference that I have with her, I'm not sure what that says about the attorney-client relationship.
I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously believes in me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am.
Did you guys catch that? She's on an adventure. She was mad. I remember her being really upset that George had stolen the adventure fund, but here she is on an adventure. So she thought that that was her only chance for an adventure with Son. But here she is all on her own, adventuring.
That I am on, and I'm doing my best to. I believe that God obviously believes in me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope, is to hope that she will come in with a gentle, softer side and actually listen to what it is that I'm saying.
Listen. I think that's one of her first instances of listen. Actually listen. I feel like you're hearing me but not listening.
And see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
The defendant, they're calling this a, quote, unique adventure that she's on. Her trial
This unique adventure.
set to begin on October 7th, where she's going to face charges in the murder of her boyfriend, Jorge Torres. She admits to zipping him up in a suitcase and maintains that his death was an accident after a night of drinking.
Oops.
Still with us, criminal defense attorney Marie Pereira and criminal defense attorney Josh Schiffer. Marie Pereira, based on what you just saw from her inside of the courthouse, thinking back to the pro se defendant.
But she seems very well thought out. I think that they can tell.
I think she's a quite
Is that it
the
for
integrity of the council is an
we'll go to the next one.
extraordinary.
First, we want to update you on what is going on in the Sarah Boone case.
Yes,
We're
we do.
expecting opening statements in that case as possibly this afternoon, but more likely tomorrow.
Welcome to the feed, West Coast Mesh Fighter. We're just getting started. We're a couple videos into kind of a greatest hits package of Sarah Boone's pre-trial and underviewed shorter videos. We're just getting into the ruling on her snacks motion. James Owens put forth a motion for 5 peppermints and a bag of candy and 2 cookies. The cookies are already a no-go because Kranick's aware that they get cookies in their regular package. But let's see how the peppermints go.
Because things keep coming up, and this morning something came up, a couple things. The prosecution upset over some discovery that they were handed apparently this morning, some JPEG images on a drive. So they have asked the judge for a hearing, a Richardson hearing. They are crying foul. Let's see what the judge says outside the presence of the jury that still hasn't even been picked yet.
Oh, hold on.
But there's Sarah. She's in the courtroom. We'll also find out about her snack request.
Good. It's like, tell me about the snacks.
With regard to the Richardson hearing, with regard to item 6 in the defendant's Fifth Amended Reciprocal Discovery.
So now, the Richardson hearing, if I remember right, it was because there was images of her son in a snow globe. There was a picture of something taken, and there was a picture within that picture, and it shouldn't have been part of the evidence. But Sarah's side included it, so the prosecution objected to it. Like, we don't want item XYZ to be part of it. That's what I remember anyway. Let's see if that's what it is.
The court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay.
So no, this is different. This is her trying to get in medical records, probably for her stab wound.
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to...
Paul Klink, NYC, reminds us the line from Peter Pan, "To die is the greatest adventure." Know that, Sarah.
...the evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
I don't remember any of those names ended up testifying.
Response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts from what I would expect.
But they didn't end up needing the 911 people to testify because they have the tapes. It's like, is that you? Is that you? But yeah, they were able to introduce the 911 audio without the operators.
Not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Good morning, Ann McCallum.
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense.
The sidebar too, like this is so, we're kind of casual, we're chatting in chat, but Boone allegedly recorded 2 videos showing Torres screaming for help. I can't fucking breathe. Seriously. Like, it's so fucked up, and for it just to be like a sidebar to the coverage, but it has to be. You have to move on, but I don't know. It's a stark reminder of the reality of this case.
Provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on.
Hang on.
Juror number. Yes, let me address that. Can I have the thing again?
Look at that pensive look. What about my snacks? I don't want to ask, but we're supposed to hear about them, right? Feed me. I feel like you're trying not to feed me.
If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that Jury Services has told us the juror in seat 25, wearing badge 63, called sick child. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated. Juror number 25, wearing badge 63, will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the ora tennis motion as to Ms. Boone's request for snacks, the ora tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial.
A little look back like, thanks. Fucking ruined that one, Owens. Thought you told me I'd get the snacks.
Other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all. We need to address, State, before we report back to 29. Ms. Boone is being... With regard to the ora tennis motion as to Ms. Boone's request for snacks, the ora tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Sarah Boone with a look there.
With a look
right away with to the
hey Sue
motion for snacks. Being
good day to you.
She will receive what everybody else receives. That is the ruling for the judge. If you missed it, she asked for some specific snacks in this case.
Specific snacks.
She felt like she needed them. Let's watch that to remind everybody what she said.
You know, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day.
So that was the ask, and the answer was no. So there you have it. Eric Schwartzreich with us. Your thoughts on Sarah's snacks?
I love the look of the expert. Like, we need somebody to comment on Sarah's snacks, but he has to have the right look. This is the guy.
Hungry mouths do not get fed unless they ask. Let's snack on this. And she's asking for things that are interesting over there. Things that typically you might expect a child might want. Peppermints, the other list. I don't know if there were cookies on there, but
yes,
here's
cookies.
The reality. Well, this case is hard.
I just missed him. This guy looks to me what I expected James Owens to look like when I heard somebody was parachuting in for the end of the trial. I would have expected a guy like this to be the guy that, like, hey, Judge, I'm here. I'm the guy. I'm going to take care of this. Don't worry.
You might expect a child might want.
He's probably really good. You have to have a certain amount of skill to be able to be yourself. So respect to him, but he's definitely got a look that I would have expected as the guy parachuting in for Sarah's trial. James actually looked like a lawyer. He acted like this guy looks, but this guy's probably super good at what he does in order to dress like this and still get clients.
the other list. I don't know if there were cookies on there, but
yes,
here's
cookies.
the reality. Well, this case is a suitcase, and the lever being placed into a suitcase and the game of hide and seek. She is seeking the battered spouse syndrome. It's an evolution that's come a long way, which really is an extension of self-defense, the castle doctrine, no duty to retreat. So just that type of request, that permission. It's a very sad case. Can I have snacks? Can I have these peppermints? Can I have these cookies? Someone that was battered, someone that was abused. I mean, I find that aspect interesting. I mean, her look, she seemed more concerned about the snacks. I mean, she's on trial for very, very serious charges with very serious consequences, but she's saying, and the defense is going to try and say that she was battered. And
4 peppermints would have, she overdid it, ADG Forsyth. She played her hand too strong. It's like 3 or 4 peppermints, reasonable. 5, come on. What kind of precedent do we want to set for future criminals? How are we going to afford all those peppermints?
they lay that foundation.
This is Florida. We can't afford 5 peppermints for every person on trial.
They put on the proper witnesses, the doctors, and you battle the experts. They're going to try and help towards her self-defense claim that she was in fear, that she had no choice but to do this. As far as the Richardson hearing, discovery, fair play, the judge is trying to wrestle with, whether or not discovery
All right.
for the
I'm
viewer.
going to go to the next video. He's got a little bit more commentary. Everything in this playlist, I'm going to publish the playlist in the description. So any of these videos that I'm skipping past, if you're on the replay crew or if you're here watching live and you want to watch them in full after, this playlist will be available. There's a couple of longer videos towards the end we're not going to have time for today too. So if you just want a fun Sarah Boone playlist, Sarah Boone playlist. No, you can get the playlist at the Patreon, but fuck them. Fun Sarah Boone videos is what it's going to be called. It's unlisted right now, but I'll make it public afterwards so you can find it either in my playlists or in the description after this video.
Let's go ahead and call.
This video is titled Laura Quits on Sarah Boone, Withdraws from Suitcase Suffocation Case. This is an interesting video because it's a rare one we get for this angle. We usually get Sarah in profile on the other side of the courtroom, so this one might be in a different courtroom. In any case, I think this may be Frank Bankowitz. Yes, Frank Bankowitz is going to withdraw, so it means I think this is Judge Wooten. So people who came to the case at the trial maybe hasn't seen much Judge Wooten. This will be a fun one.
The Boone case.
State of Florida versus Sarah Boone, 2020, CF 2603, state.
Dave Cacciatore on behalf of the state.
Defendant,
Frank Bankowitz.
please raise your right hand. Do you solemnly swear affirm that the testimony you shall give to the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Yes.
Can I have JAC announce themselves as well?
Yes, Audrey Moore for JAC.
All right. So we have multiple matters scheduled this morning, one of which is Mr. Bankwitz's motion to withdraw. My reading of the law is I feel like I have to address that motion first and rule on that before I can address any other motions that would be heard today. So, Mr. Bankwitz, I'll start with you. Tell me why you're moving to withdraw.
Judge, the letters that have been coming to your honor, the derogatory berating of my services in this case, I can't effectively represent her. She doesn't trust me. She calls me a dud, I think, a buffoon, on and on and on and on. And no one should have to endure.
Sarah's insults are so 1920s, like a dud, a buffoon. I know you are, but what am I? That's my name. Don't wear it out. She's so... Oh, he's such a buffoon. It's like a Bugs Bunny insult.
That type of derogatory comments and expect to effectively represent someone, especially in a murder case.
Ms. Boone, I read your letter dated August 26, 2023, and your letter dated August 30th, 2023. And just so we're clear, I read all of the letters that you send to the court.
Just so we're clear.
Whether I respond or not is based on what's in the letter and whether I'm asked to actually do something that's within my purview as a judge or not. If I understand correctly, you have now decided that you think it would be best, in fact, if Mr. Bankwitz was allowed to withdraw. Is that correct?
Yes.
All right.
Yes.
Do you understand by him withdrawing, I'll have to appoint another attorney? Do you understand that?
I do.
And that attorney's not standing here, so we're not going to be able to address, and I'll give the state a chance to talk to me as well, but assuming I grant this, we won't be able to address the other issues that were docketed for today, which means I'm going to have to reset your case for a later date. Do you understand that?
I'm not sure what items it is you're speaking of. I haven't received a copy yet of the letter.
All right. So we're having a hearing today in regards to authorization for payment for an expert that your attorney believes he needs to defend you in an issue about the compensation of that expert, which is why JAC is participating today. I don't know if your next lawyer is going to think that that expert's the right person to use, or whether they're going to go a different route after consulting with you. And even if they did, they're not standing here. And once Mr. Bankwitz is out, he's out. He can't argue the motion. So do you understand that?
I fully understand.
Fully understand.
Mr. Cacciatore, normally the state takes no position in these issues, but there are limited circumstances when the state doesn't take a position. So are you taking a position on this motion withdrawal, Mr. Cacciatore?
No, this would be one of those times where we would be not taking a position.
If she wants to get rid of her sixth lawyer, we have no position on that.
All right. So I'm going to grant Mr. Bankwitz's motion to withdraw. I'm going to appoint, let me find my list, Attorney Winston Hobson to represent Ms. Boone.
Winston Hobson, we hardly knew ye.
In regards to the other matters scheduled today, I'm going to take no action on them at this time until Mr. Hobson can, well, in regards to the motion involving JAC, I'm simply going to take no action on that motion at this point in time until Mr. Hobson has a chance to review it and determine whether he wants to proceed with that motion. I will address the pretrial because today was also supposed to be pretrial. Here's what we'll do. Let me just get my calendar up. As far as pretrial conference, I'm going to set this case for pretrial conference on Tuesday, November 28th, and a trial period starting Monday, December 11th. I think any earlier period of time would be unrealistic for Mr. Hobson to get on board, get up to speed with the discovery, and determine how he wants to proceed in regards to any experts. But I will set a status hearing on the case prior to that.
Interesting in the descriptions here is a quote, which I'm sure he's going to say, but I'll say it anyway. If this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are, the judge says to Boone. Well, this is compelling, isn't it? Just looking at the calendar, trying to set dates. I should have not paused it.
Set a status hearing on the case Monday, October 30th, 2023 at 10 a.m. That'll be for the purpose of making sure that Mr. Hobson's on board, some sense of where he thinks things are, how realistic he thinks the November pretrial is, any other matters I need to address with him at that time. Now, Ms. Boone, in just a minute, they're going to take you back to the Orange County Jail. I'm going to suggest that you talk to Mr. Hobson about the various other issues you raised in your letter dated August 30th, 2023. One other thing I want to talk to you about, we had this conversation once in the past.
If this becomes a problem.
Clearly, your working relationship with Mr. Banquets was such that it deteriorated to the point where the two of y'all just couldn't work together to defend your case. So I'm not going to try to referee how that played out, why that unfolded the way it did. But one thing I want to caution you about, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. You have a right to a court-appointed lawyer. There are certain decisions a defendant gets to make in the defense of their case that are absolutely theirs, such as whether they go to trial or not, such as whether they testify or not. But there are many decisions in a case that a lawyer gets to make. And while you certainly have a right to consult with your lawyer and discuss with your lawyer, they don't automatically just do whatever you say. They use
wait till I get James Owens, Judge. He'll do everything I say.
their professional judgment and experience and look at the evidence, look at the law, and do the best they can. Also, you've got court-appointed counsel. As I've explained to you before, court-appointed counsel rarely have the luxury of representing one person and only having one case to focus on.
Mm-hmm.
I have concerns that your expectations of what any court-appointed counsel might do as far as spending time with you and the depth and degree of communication may be unrealistic expectations. You always have the right to retain a lawyer to represent you, and then that's between you and that lawyer. You can demand whatever expectations that you have as part of that agreement. But when it's a court-appointed lawyer, you have to accept and understand that they have other cases, other courtrooms, other responsibilities. And I'm cognizant of that when I'm addressing these types of issues about communication. So that's just food for thought, nothing to do today. I don't need a response from you. I just wanted to make sure you were aware of that and were thinking about that as we proceeded forward. So again, the court minutes reflect that I'm court continuing pretrial. I have granted a motion to withdraw. I have appointed Mr. Hobson to represent the defendant, and I'm taking no action on the motion, the ex parte motion for cost directed where JAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
I bet you are. Oh, that's so good. Am I able to say anything?
Ex parte motion for cost directed where JAC is responding. Ms. Boone will be returned to the Orange County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
Okay, that's got to be a video. I got to do this somehow.
County Jail pending disposition of her case.
Thank you, Judge.
All right.
I'm not able to say anything.
Oh, that's so good. I am so glad that we were playing through some of these. The last time, I promise.
I'm not able to say anything.
I think that's the first opportunity someone took to not let her say anything. Like, can I say one more thing? Fine, but no, you've got nothing to say here. Move on. Move along, Boone. Thought I was going to say bitch, didn't you? But no. Move along, Boone. Move along. We're at 7:45 a.m. my time, which means an hour and 15 minutes left in this show. The next clip I have coming is a 25-minute long clip, and this is where Sarah Boone is negotiating a stun cuff. She doesn't want to be shackled. She wants to be able to move around the courtroom. Later, she'll ask for a skirt, but at this point, she's just asking for a stun cuff. And the judge is assuming pants, but y'all are assuming. You guys don't realize she's going to want to wear a backwards skirt with a slit in it. So yeah, I have that. I also have Brian Boone's testimony from the trial. I know that's not pre-trial, but it's just another, I think, highlight that's a bit underviewed. He was on so early in the trial, we forget about him. I have pre-trial of Sarah testifying that she was hungover when the cops questioned her. That'll probably take us to the end of my show. And then I have a couple longer clips here. So at the end of my show, I am encouraging everyone to jump over to Reporting Live from my sofa. Paul is doing a rewatch of the Afroman trial. He'll be watching Randy Walters and Officer Poundcake as part of his coverage today, I believe. So yeah, I'd encourage everyone to jump from my stream into his, and I'm going to try and run right up to about 2 or 3 minutes before, just to go offline just before he's coming online. So, and then I'll see you guys in his chat because I want to see his coverage. He was having such a good time watching Lickin' Little Lisa. It's it validates, like, I feel good about doing the early coverage on the trial. Like, seeing more and more people covering it late is makes me feel like, okay, my instincts are right here. And yeah, I'm just really enjoying his take on it too. So I encourage everyone to move over with me to watch that as the next part of the morning. Sorry, I said last time, but...
I'm not able to say anything.
The look on her face. Yeah, little prison chic there. That's make her...
But it was never proven, correct? Because it was dropped?
It was dropped. Doesn't mean it didn't happen.
Okay. I'll be working on the others with the corporals and the sergeant.
I don't think she's happy, Addie. I think that look is that sort of smug, I knew they wouldn't let me talk. So it's the I was right face, because... yeah, it's not a victory face, and at the same time, it's an internal validation of, like, I knew the whole thing is rigged against me. Wait till I have my chance to say my piece. This is a great hearing, too. You can already see by her body language. I'm not a body language expert, but she's not having it. She's here. This is my time to talk, and I'm going to talk, and I don't like... X, I don't like Y, I don't like Z. There's even a new handler. This guy's not normally the guy who's in charge of her. Oh, she gets to ask the guy in the stand questions too. Okay, this is all great. This is good. I'm going to let her interact with you in the chat.
For the supposed non-compliance.
Oh.
Thank you for the dates and the information.
Volume good?
Yeah, do you have any other questions?
It's quieter, right?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been.
Correct. It's in your history.
Okay. Thank you for the information.
Any follow-ups, Dave?
No, Your Honor.
Fine. Thank you, sir. Anything else, Dave?
Nothing to say.
Okay. I see Deputy Barnett here. Could you come up, sir?
Giving it a slight audio boost. Let me know if I've gone too high, but I think this hearing is a little quiet. So go 1 decibel.
Yes, I do. Sir, good afternoon, or good morning, rather. Could you state your full name and date of birth for the record for me?
My name is Chad Barnett.
And not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm the Deputy Sheriff at the Orange County Courthouse.
I want to give him credit because he listened. He said, spell your name and date of birth. You want me to spell my date of birth? Never mind. Just spell your name and give us your date of birth. Sarah Boone, there's one of my shorts that I think Cranicked is the title, but Judge throws her a curveball. Instead of asking for name and birth date, he says, say your name and spell it. And Sarah Boone, 101077, and spell it, please. But good for this cop is listening. I'm going to even go back for that. That's kind of funny.
See Deputy Barnett here. Could you come
West Coast loves to sound good. I'm becoming a sound engineer. I've got all these filters set up, but I appreciate the constructive criticism early. People were very supportive. There was a couple people that were just kind of blunt, and at the same time, all those comments led to the good sound that you're getting today. So thank you, everyone that contributed to sound feedback.
Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Jeff Barnett.
And not your date of birth. Sorry. Could you spell your name for the record?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called a stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's a box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to be walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons so there's no accidents. If it had to be used, it would cause a shock to the location, causing a great amount of pain, causing the defendant most likely to fall to the ground, and we could.
I'm going to take a little pause here to show you guys. I'll just look this up in the background.
Face it right at the arm.
Very simple. Make sure you have contact. Strap through.
All right.
Now we instruct the inmate. You will comply with all the regulations that we give to you.
Okay. But you know what? We're going to now. There you go. It's on.
And these are on taut. So
You can see that smile of nervousness.
The inmate that he will comply with all the directions. If he fails to comply with any of the directions, he could be electrocuted at any given time, or shot, stunned, not electrocuted. He will be stunned at any given time. So with that, the inmate acknowledges, do you understand that? And the inmate looks and he doesn't say anything. I'm going to ask you one more time, do you understand those acknowledgments? He failed to hit him. Yeah. There it goes. Now it's on a cycle. You've seen how the cycle worked? Now it's not done where it takes him and then he mobilizes.
All right.
Yeah.
That's not so bad. I wouldn't have mind seeing that happen to her. Go back.
Other than what you've already identified?
Just to follow response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it is at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a level 4 level. That is pretty much fighting, escaping, attacking another person.
Okay. All right. State, do you have any questions to Deputy Barnett?
No, John.
Right. Ma'am, do you have any questions for Deputy Barnett?
Mm-hmm.
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun cuff.
Stun cuff.
And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of your leg.
Oh, I guess it hurts more than putting it on the wrist then.
That it doesn't need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We would take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to your leg.
And it's a one-time waiver?
Each day you will have to recite the waiver.
Okay, and so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply?
Yes.
And
I guess these are good questions. You don't want to find out that, well, this gets inserted between your buttocks and this has to go here. Like, oh, I didn't realize all this. So, not our worst questions to be asking.
Yes.
Thank you.
Any follow-up?
Nothing to say. All right.
Oh, I have.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You would be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right. Thank you, sir.
Yes, thank you.
State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any?
The shackle motion. That's what I will forever call this hearing, the shackle motion hearing.
Things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
There is...
She doesn't know what just happened. Hold on. That is awesome. I asked my questions, but hold on, we're done here? What just happened? Was that an option, or did I just agree to something?
Or case law addressing reasonable measures for movement by a defendant in the courtroom.
What's she writing here, too? Reasonable measures for movement in... Stupid note-taking.
So that is an option.
Oh, she's writing option.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an action?
The supposed 3 non-compliance. I wonder if one of them was using a tablet when she knew she wasn't allowed to.
Option?
I cannot answer that question because that would be me providing you legal advice.
Which I am not able to do.
Or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
And just to be sure, this trial doesn't matter. That all of this didn't matter once James Owens came on. I guess some of the stuff that got negotiated here, I don't know. I don't think any of it really mattered because this was all meant to be her freedom to defend herself as a pro se litigant. Litigant is the civil trial. In any case, in able to freely use the courtroom. That's what all this was about. So maybe that's why it's an underviewed bit compared to trial and interrogation, but still fun. Glad everyone's here with me enjoying it too.
I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay, well, you could have done that with the fucking leg irons.
Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement, and I interpreted that as you wanted to move, as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of...
And you know, if he hadn't considered that, she would have been like, I can only move my hands. I really wanted to be able to move around the court.
Shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me, just for the majority of my...
You don't ask questions. I want to be the focus of your attention. Ask me all the questions. I won't give you answers, but I'm just offended that you didn't ask.
Motions and letters and so on that I have supplied the court for more information.
I'm going to cough, but I'm going to try and get to my mute.
It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need
Realized I had the headset on and that would be loud.
Or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed, the defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right.
Nice zoom, cameraman.
Which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists. In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
go ahead.
It's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not, so that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right? Okay. Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here.
That's what we were talking about.
I have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion?
Kranick stops asking this. So right there he says, well, yeah, it's even up on my captions. Is there anything else you'd like to tell me? He stops asking that at a certain point. He starts asking very specific. Is there anything you'd like to tell me about XYZ? But he learns quickly not to give her that much kind of room to run.
To be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial. Is there anything else that you'd like to tell me about those requests?
I don't know if you've
So already reins it in. Anything you'd like to tell me about those requests?
See my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
She's all for solutions.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett, who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention.
Very reasonable questions, Mr. J. So yeah, that's an option. She could sit there. She could be chained to the floor. They could have to sit at their table, and then Kranick just tells the jury, this is how we operate. The jury accepts, the judge says, this is how I'm running the courtroom. Counsel will sit at their table. Pro se defendant will sit at her table, and they don't have to be any the wiser that she's chained to the floor.
It all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed.
I think that you should make Mr. J and Mr. Cacciatore also be handcuffed while they prosecute me. That would be fair.
To be able to progressively and actively participate properly in the same as others.
And remember all of this. So this is a 25-minute waste of time. We're stretching into about 45 minutes of our time. And then on the stands, Owen asks, well, you didn't always weigh 135 pounds. Oh, you mean since I was incarcerated? Like, one of the first things she does on the stand is give up the fact that she's been in jail since this happened. And all of this is moot, even though this was moot before that. Yeah, she just completely, oh, well, you could be up here in your oranges then, or your jail blues.
Simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled? Or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy Lowton identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. And the privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have...
I'll wear it in my cell. I'll do whatever I can.
No, I just address all the concerns, which is more of the court's plan.
Got it. All right. Thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of the stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the court's would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so ma'am, the court's gonna grant your motion and that you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with the Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
We've been through this.
The only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Like she thinks she's going to be brought in like the Gimp in Pulp Fiction, her trial.
The other item I have on, yes, sir.
Cameraman's a little foot guy, just trying to get in his sneaky shot before the end of this. I think Quentin Tarantino just took over the film work for this one.
The sheriff's office is looking for
Mention Pulp Fiction, get a foot shot in
the
the
situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedures, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and
Pulp
the state,
Fiction's
and
fun.
your jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off
In
when
advance.
she gets up here.
Yeah, I understand that. I'm just worried about the fairness here in the courtroom, especially when we
How you
bring
doing,
in,
Dabs for Dummies?
a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. And as identified by Sergeant Barnett, you're going to have to sign that waiver every day.
I'd like to wear a mini
Of
skirt.
course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
be
is
just-
under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience of how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to.
Good
You're not
point,
gonna be able to
pretend
walk
judge.
all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'll be able to go and not go.
There'll be basically invisible lines on the floor, like you're allowed to go from here to here and here to here. But if you go outside those lines, we're going to push the button. You're going to get zapped in front of the jury and everyone. Oh, wouldn't that have been great? Wouldn't that have been great, man? You know, you think of the alternate universes. That would have been a fun one to see her represented herself and constantly stepping out of the lines. Sorry, Your Honor. I just wanted to walk to the left for a second.
The same limitations to the state, okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that.
I was gonna, either you could do it or I was gonna have the deputies do it. So, ma'am, I envision that because you're gonna be able to move about freely and our jurors are not gonna know that you have any restraints on you and they're not gonna be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you.
So this is Brian. This is the actual trial. This is where Brian takes the stand. I think the interesting thing to watch for on this rewatch of it is, it's Mr. Cacciatore, so this must be the cross. Well, okay, interesting too. But the main thing was Owens had to keep his direct super tight so that Mr. Cacciatore and Mr. J couldn't ask about a lot of other stuff that Brian could have easily testified to. So they could only cross him on information that was asked in the original testimony, which was fairly narrow. And it's only a 10-minute bit, but I'm still kind of interested. I don't really remember where he went with it. I remember his family court testimony now better than his criminal court. Meowgarita. Oh, give me one Meowgarita. I'm going to open my legs.
Sir, good afternoon.
Do a bit of a man spread here.
After seated, if you could please state and spell your name for the record for us.
Brian Boone, B-R-I-A-N-B-O-O-N-E.
I forgot. He forgot how to spell his name. Oh, I love that for Brian. I'm going to go back just a half click. He's nervous.
A-N-B-O-O-N.
For the record for us.
Brian Boone, B-R-I-A-N-B-O-O-N-E.
Thank you, sir. You may inquire.
Your name is Brain Boone. Oh, I'm sorry, Brian Boone.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you know the defendant?
I dated her for quite a while, and then we eventually got married.
When you say you dated her for quite a while, how long are we talking?
I met her in the late 90s, and I believe it was around 2005 when we got married.
Did you have any children as a result of your marriage?
Yes, we had one son.
And how old is that son?
He is currently getting ready to turn 14.
Did your marriage with the defendant last?
No, it did not.
And approximately when was it that you separated and began proceedings for divorce?
Probably 2017, I'm thinking maybe.
And at that time, when was your divorce actually finalized?
Maybe it was 2016. I think the divorce was 2017. I believe.
He looks so impish. Well, that's a good one, too. He's very expressive. I forgot about. Look at that. I guess it's been another year.
After your divorce, what was your custody arrangement with your son that you had in common with the defendant?
She was supposed to have him on Mondays and Tuesdays. I would have him Wednesday, Thursdays, and then we'd alternate Friday through Sundays every other week.
So 1 week you would have 5 days with your son, and another week she would have 5 days with him.
Correct.
On paper.
And was this still the same custody arrangement in February of 2020?
Yes.
The other context for this is Owens was trying to impeach Brian's testimony at this time, saying that it was in his best interests for Sarah to go to jail so that he wouldn't have to be on the hook for the alimony.
In February of 2020, did you have, do you recall the events that occurred, I guess, first on the late evening.
I'm sorry, not he was going to. He was prepared to, even though he called Brian as a witness. But I know that was like a, if it went there, that was somewhere that the speculation at the time was that he would follow up by, and I think it was in a pretrial hearing. They said that they couldn't go there. So that's why it's all hands off. Anyway, I'll let the trial coverage cover itself. Shut up for a couple of seconds.
Of February 23rd, 2020.
On that evening?
Yes.
Well, apparently Sarah called me at one point during the night.
Hey, Blue Giraffe.
Do you recall about what time she called you?
I think it was 11 something.
When you answered the phone, how did Sarah sound on the phone?
She sounded like she had been drinking, was pretty drunk.
Brian!
Were you able to understand what the defendant was saying?
Somewhat, but she woke me up. I had work the next day. I was asleep when she called. She's done this before, calling me late at night, and generally
Brian! You gotta come over, Brian!
kind of just try to ignore it, so I wasn't really paying attention.
Who was she living with at the time?
George Torres?
When she called you late that evening, could you hear George in the background at all?
Not that I remember, no.
Did you pay much attention to this phone call?
No.
Now, the following morning, on February 24th, 2020, did you begin to call the defendant?
Yes, I did.
And approximately
Bless you.
what time did you begin to call the defendant?
I think it was like 11 o'clock or something.
And why was it that you were calling her?
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Do you remember at what time on February 24th you actually got in touch with the defendant?
I think it was like 12:30 or something.
And when you actually got in touch with her, what did she tell you on the phone?
That George was dead, and if I would come over.
Did she say what happened to him?
I don't remember if she told me then on the phone or when I got there, but she told me they had been playing hide and seek and that she fell asleep.
I fell asleep.
I told her she needed to call 911 and that I would come over as soon as I could.
And this is on your first phone call here at approximately 12:30
Yes.
on 2/24/2020.
Yes.
Did she call you again while you were en route to her residence?
She did. She called to find out if I was still going to be coming over.
And when you spoke with her while you were en route, what, if anything, did you advise her?
I told her she needed to call 911 and told her I was on my way, but she needed to get somebody over there.
Which she didn't do.
How long did it take you to arrive at her residence?
From the first phone call, or?
Yes, from the first phone.
Well, I mean, I live a minute or two drive away, but I had to get my puppy. We had just gotten a puppy recently. I had to get him in
Non-responsive,
his crate
objection?
and stuff like that, and put something on because I was working from home. And Total time, maybe 10 minutes.
When you arrived at her apartment, tell us what she told you when you arrived.
George was dead, and once again, I don't remember if she told me now or before that they had been playing hide and seek and she fell asleep, but I, at that time, told her again she needed to get 911 called to get somebody over there.
Had she called 911 at this point?
No, she had not.
So you've advised her now 3 times to call 911.
Yes.
Did you go inside of her apartment?
I walked in the front door into the little tiled area, like entranceway thing.
What, if anything, did you observe when you made it to that point?
Looking into the living room, I could see like the end of his feet and maybe a little bit of some legs that were kind of coming out around the backside of the kitchen area.
Did you continue to go into the apartment?
No.
Where did you go?
Sarah told me she was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her.
Go outside and have a cigarette and a drink. Remember that. Remember that. Know that. Let's go out and have a cigarette and a drink. Then I'll call 911. Hurry! Hurry! He just gurgled!
I told her that I didn't really feel comfortable being inside. She was going to call 911 and go outside and have a cigarette and a drink and asked me to come out there with her. And I told her that I didn't really feel comfortable being inside. And I went out front and got in my car and waited for people to show up.
Did you witness the defendant call 911?
I think I was in there when she dialed it and first got somebody on the phone.
I think that was the distraction he needed to get away from her. As soon as he heard her, like, 911, 4748 France. 3. That's like, that's it. 3. That's my cue to leave. GTF the fuck out of here.
But I wasn't there for the whole conversation, no. I was outside.
Did you stay there at the scene while police arrived?
Yes, I was there. I was part of it. I knew I'd have to talk to somebody, so.
Thanks, Sarah. Now I got to stay here. Fuck you. One final time.
Law enforcement?
I did.
Sure, I have no further questions at this time.
Thank you. Any cross-examination?
Judge, we want to reserve our questions for when we call him in our case.
Okay. All right, sir. You're subject to recall.
Okay.
Thank you.
Thank you.
Hey, the deputy's got a mover.
All right, so this will be the last video we watch as this stream. You see I've put up a timer in the bottom. Reporting live from the sofa is, I think, the podcast channel is covering the Afroman trial. He's covering Officer Poundcake's testimony, as well as Randy Walters, which you might know from the song Randy Walters is a Son of a Bitch. His first couple hours of coverage has been hilarious, so I encourage anyone who's watching this stream, pop over with us in the chat, drop a blue heart and a sofa in there, let him know Dan D and the finest and dandiest are in his chat, and yeah, that should be fun. So we'll get right into this one. This is Sarah in a pretrial hearing. They're trying to throw out the car interview at this point because she was too hungover to give a proper interview, but she doesn't get drunk, so it's going to be an interesting tightrope for Sarah to walk. It's 26 minutes long, so we might not get to the end of it, but we'll come back to these. This is a fun playlist, and this playlist will be in the description. If you're watching it on replay, you can watch all these videos as well. I've got some longer ones in here we didn't get to, so we might just start with this one the next time and revisit what we enjoy from this. Here we go.
Ma'am, you've already been sworn. Counselor, you may proceed.
And would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
This is awesome because she's handcuffed, so she can't fuck with the microphone like she normally does. Well, I guess she's handcuffed and shackled. And that's why she instantly fucks with it when she is able to, like, oh, I've been wanting to fuck with this microphone since my pretrial hearings.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020? Was that the date of this interrogation that we're here for on this motion?
Ooh, that's loud.
All right. Let me take you back.
Hold on. Now, if I remember the original this trial, that this was super quiet, so they've probably done some boosting on the courtroom audio, so I'm just going to get rid of the boost I've put on. Sorry, I know this has got to be better than trying to do it live for you, so I'll just talk my way through it. We'll get rid of the boost, 0, exit out of that, and we will try and reduce the screen volume slightly as well. Sorry, Mr. Owens, just a little too much here.
To the morning of
Okay.
finding George Torres in the suitcase.
Acceptable audio?
You called 911? Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
And yeah, the audio, like, I'm more looking for volume levels rather than quality levels because it sounds like shit. Like Owens is super boosted, but if you can hear it, then it's good. If you can't, then it's not good.
What mental state did you have at that time?
I was very confused.
Very confused.
It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
So, perfect. Pause there on her face. What we're watching here is a bit of an unforced error. Sarah doesn't need to take the stand. This is a preliminary hearing. There's no reason for her to put a bunch of stuff on the record, but this is immediately why Mr. J and Mr. Cacciatore are objecting, because they're changing the story and they're getting it on the record that there's been different versions of the story, and if she gets on the stand it says something different. It's not good.
Her interrogation is the next day.
The state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
Yes.
It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained, and it's stricken.
All right. Did you speak to the deputy about what had happened?
Yes.
Okay. And then Were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay, how long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesell asked me was if I owned a phone.
And what did you tell them?
I told her it was on the kitchen counter.
Chelsea Kepsel is how it's pronounced.
What
Kepsel.
happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesell.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it,
I thought she said she used her face, but I guess she used the passcode for Chelsea. She definitely said that's how George would get it, is just hold it up to my face, which my little joke is, George used to hold my phone in his crotch. I think he figured if he just pressed it far enough against his junk, it would be a match for her face and he could unlock it.
Did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
Another one to say says she can't tell the jury that she had it on Face ID. That would prove she's a harmer. Just for the record, this is pre-jury. This is still, and this is why it's weird that she's even giving testimony at this point. Like, even if she wants to testify at the trial, there's no reason for her to put all this on the official record early. It just gives them more to tear apart from the prosecution side. But you can see she's here in her prison smock with her ID. So, not hiding nothing from no one.
Question about those videos at the scene.
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove.
Okay. What was the reason that you wanted to stay over there the night?
Terrified. Oh, that always pauses it. I just changed my camera to put the cat and dog in the background for the last 10 minutes, but I realized that sometimes pauses my screen, and it just did. So I think I can refresh it just by remembering where we are here. We're at 8:31. We'll go to the next video, and we'll come back. No, still just sound. Okay, hold on. Video capture. Okay, what have I done? Oh, I shouldn't have done it. Refresh. Because I was terrified of his family. Maybe we'll hide it. No, that's the wrong one. Oh, I've messed this up. Screen capture. There it is. Source is unavailable. Hide it. Return it. Why is it unavailable? Please check its status. Okay. Yeah, I know an issue occurred. Go to a different window. We'll come back to it. I think we're back in action. Ba-ba-da-da.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
A happy little accident, Dan P. Thank you for noticing.
You said your phone had been seized?
Correct.
And you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowell or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
All right, thanks for
Did you
popping
call
in,
her?
Meowgie. Early show tonight if you're
Okay,
coming
about
in.
what time you called her?
Friday Night Ramble, 5 p.m.
It was around 9:30 or 10.
my time, 8 p.m.
And that
Eastern.
would have been on February the
2 hours.
24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number.
Her personal cell phone number. Oh, there's another. Yeah, doesn't matter where you screen grab her face, she looks stupid. But even stupider in pause than she does live. That's a great point there, Dan P. I just realized with a little less than 8 minutes to go on my stream, I might as well promote my night stream. Tonight, the Friday Night Ramble will be 8 p.m. Eastern Time. It's the Dan D Dozen. I'm going to be featuring 12 channels. I'm going to spend 10 minutes on each channel. We'll watch, 5 to 7 minutes of video, then have 3 to 5 minutes of commentary. And some of them will be channels that you're familiar with. Hopefully there's a few of them that are new to you. If they're the bigger channels, then maybe I'll be featuring a video that's a bit under the radar, not performing as well as some of their other videos. In any case, it's going to be the Dan D Dozen tonight on the Friday Night Ramble. That's at 8 p.m. Eastern. Hard close 2-hour show. I'm not sure if Cowboy Criminology is going to be streaming tonight. If he is, he's very welcome to come in after me, and we'll do a little bit of a Dan D raid into his chat, just like I hope people are going to do into the Reporting Live for my sofa chat. In any case, we do have 7 minutes left. That was my plug for the show. I might redo that plug again in 7 minutes and 12 seconds.
She told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Awesome.
Sustained.
I took that to heart.
Have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
Did I call for a yes or no? She said yes, and now I don't know what's pending and how to object to it.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
She assumed I would be empathetic, and she tried to make me feel her feelings. I knew what she was doing. I knew it was a trick.
Discussion about you being interrogated at the sheriff's department? No. Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well? So the next afternoon, did you drive to the sheriff's department?
I think that's the stenographer in the corner. It's not the same one as from the trial. I remember it was a blonde lady during the trial, but maybe pre-trial they have different people that come in that, I don't know. But I think that's the stenographer's chair anyway. It's weird that they frame it up with the witness, just give you the top of the head.
Tell us, when you parked your car, where you went, what happened?
I parked my car and
With my medical supplies.
left everything as regular in my car, and
Everything is regular. Bottle of vodka.
walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowell came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right. And so
Like a piece
did
of
he escort
cheese.
you upstairs?
Did.
How did y'all get upstairs?
In an elevator.
And was he,
Sarah,
What
we've
was
got
he
some
wearing?
chocolate for you. Come.
A red shirt along with his firearm, and
With his firearm.
his firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator? Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowell escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator, and walked into the interrogation room. And then we've got the video on that.
We do have the video on that. This is exactly halfway through this video. I'll pause it here. If we return to this playlist, we'll start over again from this video. This playlist will be in the description once I update the descriptions. We have about 2 minutes until reporting live from my sofa is starting. The pinned comment is a link to it. If you want to leave the chat now and go there, this is the end of the video. I'm just going to be wrapping up here. So by all means, thank you for coming. I'm going to close out. Come to my show tonight, 8 p.m. Eastern, 5 p.m. Pacific. It's going to be the Dan D Dozen featuring 12 different channels, 10 minutes each. We're going to go rapid fire 1, 2, 3, 4, 5, 6, 1, 2, 3, 4, 5, 6 through 2 hours. And hopefully Cowboy Criminology wants to go live. I know he's talking about it, and I would love to throw to him if he wants to go after I'm done. So that's today's show. You guys are so fine. I'm Dan D. Go to the reporting live from my sofa. Watch the Afroman coverage. Let Paul know that you came from my channel, and say hi to everyone in the chat. It's a Dan D raid. Ain't no party like a Dan D party. You guys are super fine and awesome.